My Lord, sir, I'm appearing for the second defendant. I'm appearing for the second defendant, my Lord.
Yes.
Yes, who is on?
My Lord, sir, I could do it on.
Yes. So you are for the second defendant and
Yes,
suit number
my Lord.
100. So where
Yes,
are the
my Lord.
others? Where are the other people in this? The other parties? Are they here?
I can see.
How are you having so much trouble?
Hello, can you hear me? Can you hear me? Council, can you hear me?
Yes.
Yes.
Anybody,
Yes.
I can hear you.
Yes.
Can you hear me?
Yes, sir, I can hear you.
I can hear you.
Hello? Yes. Can you hear me? Hello? Council, can you hear me?
Yes, I can hear you.
Yes.
I can hear you too.
Yes. My name is Barrister Wosu. My matter is slated for ruling today. NICN PHC/147/2022 between Mr. Lawrence Ono and Noira Abat Garayok and 7 others. It's slated for ruling.
Mr. Nwosu.
Yes, and we are ready.
Mr. Nwosu.
Yes, my lord.
I'm already on the matter for adoption. You are interrupting us.
Oh, I'm sincerely sorry, my lord. I'm sorry. Sorry, my lord. Sorry.
Adoption before I come to you. So please don't interrupt.
Thank you, my lord.
Processes, please.
Yes, my lord, I'm here. I'm for the second defendant.
I know, adopt your processes because we haven't seen the claimant, we haven't seen the other defendants, but you are here, adopt your own process.
I think I could have just muted herself. That's why I cannot hear her, but she's talking. Akudo, please unmute yourself.
Are you in Akudo's matter?
Thank you. My lord, sir, I can see the claimant counsel online, Mr. Onyekwere.
So Mr. Onyekwere should announce his appearance. Onyekwere, are you here? Uche Onyekwere. You adopt your process.
Very well, my lord. My lord, the second defendant filed her counter affidavit in response to the claimant's originating summons. My lord, sir, the counter affidavit is of 18 paragraphs, filed on the 27th day of July, 2022 rather. 2022. My lord, sir, will adopt same as our argument. In our counter affidavit, we have our written address. And we adopt all our arguments in the written address. And urge my lord to dismiss this suit as the claimant has failed to prove his case on the strength of the affidavit and documentary evidences before the court to warrant the grant of the reliefs sought by this honorable court. And we respectfully urge my lord to so hold accordingly and dismiss this suit with a punitive cost. May my court be pleased.
Is Onyekwere in now?
My lord, I perceive I'm in this matter. If it's number 5 on the list.
Are you Onyekwere?
No, I'm not. But if it is number 5 on the list, my lord, which is number 100, 2019,
Yes,
I am for
appearance. We have been calling on you to announce your appearance.
I'm very sorry. I'm not Onyekwere. I am Dr. Jonathan Ekperusi for the 3rd defendant. Dr. Jonathan Ekperusi, EKPERUSI, my lord.
For
the 3rd defendant. Yes, my lord. If my lord permits, I will quickly go straight to adopt our process. My lord, on behalf of the 3rd defendant,
because we're having technical difficulties, so go ahead and do the needful.
Yes, my lord. On behalf of the 3rd defendant, we filed a counter affidavit and written address.
Is the 3rd defendant in court?
No, my lord. I apologize for his absence.
Akudo, is the 2nd defendant in court?
No, my lord. We apologize for his absence.
Okay. Dr. Jonathan, go ahead.
Yes, my lord. We filed our counter affidavit and written address via the motion for extension of time on the 29th of October 2019. 29/10/2019. That's the date we filed.
I've been able to connect now. Uche Onyekwere, counsel for the claimants. I've been finding it.
My lord, the motion was granted on the 3rd of March 2020, and our counter affidavit and written address was deemed as properly filed and served on the
When was
3rd
the
of
motion
March.
filed?
Like
Sorry.
because of network problem.
It was filed on the 29th October 2019. 29/10/2019.
Okay, and it was granted?
It was granted on the 3rd of March 2020. 3/3/2020.
Okay.
Lord, we humbly adopt the counter affidavit and written address for the third defendant. We adopt the counter affidavit and written address for the third defendant. And most humbly urge on my noble Lord to dismiss the suit with cost in favor of the third defendant. We most humbly urge on my noble Lord to dismiss the suit in its entirety with cost in favor of the third defendant and against the claimant. May my noble Lord be pleased. We are grateful, sir.
No, I'm talking about you said if you add
Now. Onyekwere, I thought I heard you saying you're in court.
Well, my lord, it seems that claimant's counsel is still having technical issues. We most humbly urge my lord to deem his address as adopted.
Who is urging the court?
Dr. Jonathan Ekperusi.
Okay.
For the third defendant, that since claimant's counsel is unable to attend court due to technical hitches, that the address filed by the claimant be deemed as adopted.
Yes. My Lord, I'm sorry, I was finding it difficult to connect because of network. I am Uche Onyekwere for the claimants. Uche Onyekwere for the claimants.
Go ahead and adopt. I have your name already. You announced before.
Yes, my Lord. My Lord, we filed the.
Sorry. Go ahead. Go ahead. Go ahead.
This originating motion, dear. Yes. My Lord, we filed the counter affidavit.
Good. right. All the processes are hereby deemed duly adopted.
Yeah.
The matter is up for
Yes, my
judgment.
lord. Yes, my lord. My lord, I need
As the
to.
court pleases.
I thought I needed to cite one other authority to my lord that will also help in this matter.
There's nothing you can cite online now. We are having a lot of difficulties, and then just take it to the court. We will see if it can come in or it can't come in. Next case, please.
My lord,
Case
I'm
for
in
adoption.
my lord, my case is for adoption.
Your name, please.
BB Obu. Obu is spelled
Yes, my lord.
OBUH, my lord.
What's the suit number?
My lord, sir, so
Suit
sorry.
number
I didn't
is
get the
NICMPHC 146/2019. Dr. Chukwunoye Akujuru.
That's all right. That's all right. I have it. So announce your appearance.
My lord, my name is BB Obu.
Spelling.
Obu is spelled OBUH, my lord. My appearance for all the respondents.
Yes.
Yes, my lord. All our processes are before the court. My lord, we're ready to go on with the adoption.
Go ahead. Are the respondents?
My lord, we are for all the respondents.
Are they in court?
No, my lord.
Yes.
Not for the claimants. He filed a motion originating.
Your name first. Go ahead, Obu.
Okay. My lord, we filed affidavit of answer to claims because the claimant came by way of originating summons. So we filed affidavit of answer to claims on the 28th day of February 2020, my lord. The said affidavit of answer has 35 paragraphs and 6 exhibits.
Yes.
My lord, we also filed written address in opposition to the said originating summons on the same 28th of February 2020, my lord. My lord, we rely on all the paragraphs of the said affidavit, and we also adopt our said written address. And we urge my lord to dismiss the case of the applicants as it is lacking in merit. May it please the court.
Yes.
My lord, the process of the applicant was filed on the 28th day of November 2019. The originating summons.
What date?
28th, they filed their originating summons on the 28th day of November 2019. We urge my lord to deem the said process as having been adopted. May it please the court.
The originating process and all addresses are hereby deemed duly adopted. Your matter is accordingly adjourned for judgment.
As the court pleases. My lord, we are most grateful.
My lord, I'm interested in number 2 on the course list. NICN PH 128 2019.
My lord, I'm also in that matter for the claimants. Subject to my lord's convenience, we are ready to adopt our addresses.
Obu.
Yes, my lord.
What's your suit number? Did you say 146?
Yes, my lord. 146 2019. Dr. Chukunoye A. Akujuru is the applicant.
It's here before me. It's okay. Thank you. All right, so person now.
Yes, my lord, we are in NICN PH 128 2019.
Yes.
My lord, I am A.A. Abo. I appear for the claimants. Most humbly, my lord.
With respect, my lord, my name is L.P. Na. Na is spelled N-double-A. I appear for the defendant.
Yes, my lord, the matter is for adoption of our originating summons, subject to my lord's convenience.
If your matter is done, you can go. Thank you.
As a court pleases. Thank you, my lord.
Yeah. All right. So
yes, my lord, we are ready to adopt our originating summons, subject to my lord's convenience. It's for adoption.
Go ahead.
Most obliged, my lord. My lord, the claimant's originating summons is dated and filed on the 21st day of October 2019. 21st October 2019. My lord, it is brought pursuant to Order 3, the relevant rules of this honorable court. Order 3, Rule 1, Sub Rule 1B, and Order 3, Rule 3 of the rules of this honorable court.
Yes, brought pursuant to the rules of court, please.
As the court pleases. My lord, in support of the originating summons is an affidavit of 22 paragraphs. 22 paragraphs affidavit deposed to by the second claimant in this suit. My lord, annexed to that affidavit are 5 documents which we marked exhibits A to E respectively. 5 documents exhibit A to E respectively. We also filed a written address in support of the originating summons. My lord, we adopt the said written address as our argument in support of the originating summons. My lord, in response to the counter affidavit of the defendants, the claimants also filed a further affidavit. A further affidavit of 12 paragraphs, my lord. We also annexed 2 documents to that further affidavit, which we marked exhibits K1 and K2, my lord. We also filed a reply on points of law in response to the defendant's written address. My lord, we adopt the said reply on points of law, our further affidavit, and the reply on points of law, and most humbly urge my lord to grant the relief sought by the claimants, who are by the affidavit evidence shown that they are entitled to the relief sought. That's our humble application, my lord. We are most obliged.
Yes. Anna.
My lord, in response to the originating summons filed by the claimants in this suit, the defendant filed a counter affidavit of 16 paragraphs, also attached some exhibits, and also attached to the counter affidavit is a written address. My lord, the defendant will be adopting the written address as his argument and urging my lord to dismiss this suit based on the arguments already outlined on our processes, and urge the Lord to grant them. My lord, also in response to a notice for interlocutory injunction filed by the claimants, the defendant also filed another counter affidavit.
Sorry, counsel. Sorry, counsel. That motion was withdrawn.
Yes, sorry.
Withdrawn and struck out.
Apologies, my lord.
My lord, the motion for interlocutory injunction has been withdrawn and struck out by a learned brother.
As the court pleases.
So all processes are hereby deemed duly adopted. The matter is adjourned for judgment. You'll be notified of the date for your judgment.
As the court pleases.
As the court pleases. We agree.
My lord, may we indicate interest in suit number 2021.
My lord, permission to exit the platform.
Please do so. Thank you very much.
Thank you, my lord.
Thank you, my lord.
We're interested in PHC 43 2021.
Give me a minute. Yes, which one? That's the 43.
Wrestling, my lord. Sorry.
Okay. So announce your appearance.
Yeah, I'm trying to.
Appearances, please.
Respectfully, my lord.
Yes.
QO Epia for the claimants in this suit. Sorry, I'm trying to put on my video.
It doesn't matter. Even if I can't see you, so long as I can hear you, that's fine. Perfect. But some of you are muted. Lawrence is muted. Also muted. But okay, as long as you know you are muted, when it's time for you to speak, you can put on your microphone, please. All right, so Queen.
With utmost humility, my lord.
Yes.
QO Epia.
Yes, go ahead. Epia, for the claimant.
My home. Yes, for the claimants in this suit, my lord.
Yes. Who are the claimants? Are they in court?
No, my lord, you're not.
My lord, if it is 43/2021, may I
Yes.
announce my appeal?
Please go ahead.
My lord, if it pleases my lord, my name is P. Enebeli, Principal State Counsel. The defendant, my lord.
Go ahead, anybody. Yes.
My lord, on the last adjourned date, adjourned this matter for adoption of originating summons and other processes.
Go ahead with adoption.
Okay, my lord, we have a motion on notice. We filed a motion on notice on the 9th day of June, 2023. My lord, the motion is praying this honorable court for leave to the claimant's applicants to amend their claimant's applicants' written address in opposition to the defendant's notice of preliminary objection filed on the 5th of August, 2021.
All right. Anybody, are you receipt of the said motion notice?
No, my lord, I didn't receive any motion for amendment, my lord.
My lord, we mobilized the bailiff of the court to serve, and he told us he has served.
He hasn't received it. That means we can't go on. So go ahead, do the needful, and let's see if we can reconvene next week.
Okay, as the court pleases.
Thank you, my lord.
Most grateful, my lord.
Once that is done, goodness, you are muted. All right, once you're sorted, you contact my staff. Goodness.
Very well, my lord.
Can you unmute yourself, Goodness? We lost her there. So contact my registry staff so that they can fix another session.
As the court, please.
As the court, please. Grateful, my lord.
Yes, my lord.
Yes, I want you to take note of this matter, suit number 43/2021. There's a motion. The defendants have not yet received the motion notice. So Queen API is going to do all that is necessary to ensure that they receive the said motion on notice as quickly as possible. And then they agree on a date and then you fix it. But it has to be, the date has to be before Thursday, 22nd. Because I won't be in the country from the 22nd. I have applied for leave and received same. So I won't be, I'm going on a pilgrimage. So it has been approved by the Chief Justice. So I won't be available from 22nd. But if you're able to adopt your processes, I can assure you that your matter will be for judgment come July. But if you're unable to get it sorted, then I don't know. So liaise with them and make sure that it is sorted, and then you give me the date you agree on.
As court pleases. We're grateful, my lord.
Thank you.
Thank you.
Yes, what next? Which one?
Yes, my lord. Sorry, I was having a.
I think I left the now.
Yes, my lord. I can.
Any more adoptions? Case number 1.
My lord, I can hear you. I can hear you now. Sorry, I was having a big network issue.
Okay, I want to know or be clear that we're done
No
with all
more adoptions. I think all of them have already adopted.
except for this one with Queen at Epia. 128.
Yes, madam.
No, case number 1 has been adopted.
The case number 1 is for ruling.
Yeah. So now we all we are left with is the ruling. That's what I was saying. That we're left with just the ruling. So here's the ruling of the court.
One is for ruling. Case number 1 is for ruling.
Yes, here's the ruling of the court. Can we have the appearance for those in the ruling? Appearances, please. Where's Nwosu? Nwosu, you are muted. Unmute yourself.
If it pleases my Lord, my name is A.C. Wosu. My Lord, Wosu is spelled N-W-O-S-U. My humble appearance is for the claimant.
Nwosu is the claimant in court.
Yes, the claimant is here, my Lord.
I'm here. I'm here.
He's here. Yes.
Okay. All right, here's the ruling of the court. Yes. Here's the ruling of the court. The claimant commenced this suit by way of a general form of complaint, which was filed on the 19th day of October 2022, accompanied by a verifying affidavit, statement of fact, list of witnesses, witness statements on oath, list of documents, and copies of the listed documents to be relied upon at the trial. Arising from the complaint and statement of fact, the claimants are claiming against the defendants as follows. I'll skip reading out the claims. The claimant filed along with the said complaint a motion and notice brought pursuant to Order 17, Rule 1, and Order 22, Rule 1 of the National Industrial Code Civil Procedure Rules 2017, and under the inherent jurisdiction of this court. The said motion and notice is seeking for the following relief. 1, an order of interlocutory injunction restraining the defendant, their allies, previous agents, and persons deriving title from them for preventing, harassing, intimidating, arresting, suspending, removing, or retiring the claimant from carrying out his official duties or tasks as an employee of the service of the 7 defendants, pending the hearing and determination of the substantive suit. And 2, for such further or other orders, this honorable court may deem fit to make on the circumstances. The grounds upon which the application is made is predicated upon, I take that again, the grounds upon which this application is predicated upon as follows. I'll skip reading out that because of the technical issues. I don't want to lose connection. So the motion is supported by David. Can you mute yourself? Wherever that noise is coming from, mute yourself.
It's not coming from us, my Lord.
The motion on notice is supported by 45 paragraph affidavit deposed to by Mr. Lawrence Ono, the claimant, accompanied by 12 exhibits and a written address. The first to the 7 defendants reacted to the claims of the claimant by filing on the 23rd day of November 2022 a memorandum of appearance, accompanied by a joint statement of defense, list of witnesses, witness statements on oath, list of documents, and copies of the said documents to be relied upon at the trial. Also, in reaction to the said claimant's motion and notice, the first to the 7 defendants filed a 16-paragraph counter affidavit deposed to by 1 Otonye Mac Barango, accompanied by 27-paragraph affidavit, accompanied by 27 exhibits and a written address on 23rd day of November 2022 in opposition to the said application. The claimant, in reaction to the said counter, filed a written address and an 11-paragraph further affidavit, 9 exhibits, and reply of point of law dated 10th of January 2023 and filed on the same date. The claimant also on the 11th of January filed a reply to the statement of the defendants. Arising from the written address filed in support of the motion and notice, counsel to the claimant AC Nwosu formulated a sole issue for determination. I'll skip reading out the arguments of counsel. Next one. Reacting to the submission of the claimant's counsel to the first to the 7th defendant, Matthias E. Nwosu, also submitted a loan issue for determination. I'll also skip reading out the arguments of this counsel. However, during the pendency of the hearing of the motion and notice for interlocutory injunction filed by the claimants, the first to the 7th defendants on 23rd day of November filed a motion and notice seeking for the following reliefs. 1, an order setting down for hearing and determination the following preliminary issues arising from the pleadings of the parties. So I'll skip. The grounds upon which the application is predicated is also skipped. In support of the motion and notice is a 13-paragraph affidavit deposed to by one Otonye Mark Barango, accompanied by 2 exhibits and a written address. In reaction to the said motion and notice, the claimant filed an 18-paragraph counter affidavit deposed to by Lawrence Ono, the claimant, along with 1 exhibit and a written address on the 10th of January 2023, in opposition to the said application, arising from the written address filed in support of the application to the counsel to the defendants, Matthias Nwosu, formulated a sole issue for determination. I'll skip reading out the arguments of this counsel. In reaction to the submissions of the defendants' counsel to the claimant, AC Nwosu submitted a loan issue for determination. I said I'll skip reading out the arguments of counsel. And for the purpose of this ruling, I shall consider both motions and notice filed by the claimants and defendants together. I have taken into account the prayers sought by both applicants in their respective motions and notice, and the facts opposed in the affidavits in support of the said motion and notice. I've also taken into consideration the arguments of counsel of both parties in support and in opposition of both motions on notice with regards to the relief sought. Consequently, the sole issue for determination of the motion and notice is whether the applicants or claimants are entitled to the grant of the prayers sought in both applications. Before distilling the issues, I find it apposite to start by reiterating that the motion and notice filed by the first to the 7 defendants is predicated upon the motion and notice filed by the claimants for interlocutory injunction. Hence, it is axiomatic that resolving the motion for interlocutory injunction filed by the claimant will, in some part, take care of the relief sought by the first to the 7th defendant's motion or notice. In addressing this sole issue, I will start by addressing the motion and notice of the claimant, and I find it apposite to reproduce the relief sought by the claimant's source. An order for interlocutory injunction restraining the defendants, their allies, previous agents, and persons deriving title from them from preventing, disturbing, harassing, intimidating, arresting, suspending, removing, or retiring the claimant from carrying out his official duties or tasks as an employee of the 7th defendant in the services of the 7th defendant, pending the hearing and determination of the substantive suit. In the light of the said application for interlocutory injunction, I find it apposite to restate the purpose of an interlocutory injunction as the court held in Mrs. B.C. George against and orders against Floriana De Stefani, 2022 citation to be supplied, where the Court of Appeal quoted, where the Court of Appeal stated, and I quote, "The law requires that the rest of subject matter of litigation should not be destroyed or annihilated before the judgment of the court. It is beyond doubt that the object of interlocutory injunction is to protect the applicant against injury by violation of his right for which he cannot be adequately compensated in damages. If the dispute is finally resolved in his favor at the trial, generally speaking, interlocutory injunction is granted to preserve the property in dispute from acts or further acts of trespass, destruction, or injury, etc., pending determination of the issue submitted for adjudication by the court. C. Obeya Memorial Hospital against the Attorney General of the Federation, 1987, citation to the supplied. Based on the foregoing authority, it is abundantly clear that this court is not oblivious of the purpose of an interlocutory injunction, which is to prevent an act which affects the rest, which is the subject matter of a suit, and acts which cannot be remedied by damages. In Ugo against Ugo, 2008, citation to the supplied, where the court made an exposition on the nature of interlocutory application, thus, and I quote, an interlocutory application is an application which does not decide the rights of the parties, but are made for the purpose of A, keeping things in status quo to the rights of all parties can be decided, B, obtaining some directions of the court as to how the course of action is to be conducted, C, determining what is to be done in the progress of the course of action for the purpose of enabling the court ultimately to decide upon the rights of the parties. Therefore, an order of court is interlocutory when it does not deal with the final rights of the parties. Please see the case of Onwa against Oshodi, 1985, citation supplied. End of court, this per Peter Orderly, JCA, Ashiden was. Arising from the facts opposed in the affidavit in support of the claimant's motion notice and the above relief sought, it is the employment status of the claimant applicant that is the rest upon which this court has been called to maintain. Pending the determination of the substantive suit. Having said that, counsel to the claimant, to both the claimants, applicant, and the defendant's respondents have reckoned that there are certain factors that the court should consider in the granting of an application of this nature. Before I take those factors, I'm also mindful of the caution placed on the court when entertaining an interlocutory application not to make pronouncements that will prejudice the substantive suit or would have the effect of making the trial a mere formality and a mockery of the judicial procedure. Please see the case of Adamu against Attorney General Nasarawa State, 2007, citation duly supplied. The court in David Kodawole Are and against Oluwafemi Yemisi Owege, 2014, citation supplied. The Court of Appeal held again, and I quote, the law is that an application for the grant of interlocutory injunction pending determination of the substantive claim, including the hearing of an appeal arising from a ruling on such an application, the judex has a duty to ensure that the pending issues in the substantive suit are not determined at the interlocutory stage. Please see the case of Group Danone and another against Voltic Nigerian Limited, 2008, citation supplied. Iweka against SCOA Nigerian Limited, 2000, citation duly supplied, end of quote. A court should not delve into issues meant for the substantive suit or appeal when considering relevant interlocutory application. In the light of the above, I have taken a careful look at the claims made in the substantive suit, which is centered on whether the suspension of the claimant is wrongful, unconstitutional breach of right to fair hearing, while the relief sought in this instance is for a restraining order from disturbing, harassing, intimidating, arresting, suspending, dismissing, or retiring the claimant pending determination of the suit. I've also observed that the relief 10 of the complaint in the substantive suit, the claimant seeks for a declaration that during the pendency of this suit, the defendant cannot lawfully determine the claimant's employment or suspend, dismiss, remove, or retire him. Consequently, I shall ignore all facts relating to the substantive suit for the purpose of determining this application. In view of the above guide, what then are the factors this court shall consider to determine the grant or refusal of the application? The court in Chief Mumini Ishola Omole and orders against Chief Mrs. Christiana Oladotun Shonoiki, 2017, citation supplied. The Court of Appeal again made a detailed exposition of the factors to be considered in the grant of interlocutory applications when it held that, and I quote, the relevant factors that the court may take into account in the determination of an application for interlocutory injunction include: 1, the strength of the applicant's case in the substantive suit, and that there is a serious issue to be tried in the suit. 2, the balance of convenience on the side of the applicant, the onus of which is on him. 3, the monetary damages will not be adequate compensation for the injury from the violation of his rights if he succeeded in the action. 4, that the conduct of the applicant has not been reprehensible. And lastly, the applicant must give an undertaking as to damages to save in recognized exceptions. Please see Obeya Memorial Hospital against Attorney General of the Federation, 1989 citation supplied. Kotoye against Central Bank of Nigeria, 1989 citation duly supplied. I shall then consider the application before this court vis-a-vis the factors above to determine whether the relief sought can be granted. With regards to the strength of the applicant's case, which the applicant is required to show a possibility of success or that there is indeed a serious issue to be tried, I have considered the affidavits in support of the application, particularly paragraphs 1 and 2, which shows that the applicant is an employee of the 7 defendants as an executive assistant and was later promoted to the position of the head of administration. Then paragraphs 10 to 34 encapsulates the narrations of the applicant being suspended and removed from the office as head of administration to credit officer. There are serious issues to be tried. However, I have observed that both parties are in agreement of the fact that the contract of employment of the claimants with the 7 defendants is bound by the Human Resources Policy Manual and Procedure, which is a staff handbook, and the fact the said employment is to elapse. And the fact that the said employment is to elapse on the 4th day of January 2023, but it is the contention of the claimant that he is not to be retired until the determination of the substantive suit in view of the fact that action for his wrongful suspension is before the court. He is hereby asking the court to reserve his position with 7 defendants pending determination of the substantive suit. In this regard, the first of the 7 defendants have by their motion and notice asked the court to determine whether the claimant who shall be due for retirement from the services of the 7 defendants on the 4th day of January 2023, according to the service contract, also known as Human Resource Policy Manual and Procedure Staff Handbook, he signed with the 7 defendants cannot be so retired on the said date due to dependency of the suit. The defendants have annexed to the affidavit in support of their motion the Human Resource Policy Manual and Procedure Staff Handbook and the claimant's personal profile curriculum vitae submitted to the 7 defendants at the time of the application for the said employment to contend that by Section 8, Paragraph 12 of the Human Resource Policy Manual and Procedure Staff Handbook, the claimant is to retire upon attaining the age of 60, that the grant of the claimant's application for interlocutory injunction will prejudice the 7 defendants and will amount to a breach of the terms of conditions of contract of employment subscribed to by the claimant at the time of the employment. It is right to say that parties are bound by the terms and conditions of their contract, and in the instant case, parties are bound by the terms and conditions of their contract of employment. Please see Professor Bolagade Ayola against the Governing Board of the Nigerian National Merit Award and Orders 2022, citation to the supplied, where the Court of Appeal held, again, and I quote, parties are bound by the terms and conditions of the employment agreement or contract between them, end of quote. In view of that, I've considered the said Section 8, Paragraph 12 of the Human Resource Policy Manual and Procedure Staff Handbook, which provides thus, the retirement age for the agency is 60 years or 35 years of full service period, whichever comes earlier, in accordance with as stipulated by the Pension Reform Act. Also in support of the first of the 7 defendants' motion notice annexed the details of the claimant, which clearly shows that from the date of birth stated by the claimant, he is actually due for retirement on the 4th day of January 2023. Hence, it is the view of this court that the parties are bound by the terms of the agreement. And if the claimant feels there is any irregularity or breach of his right to fair hearing during the pendency of his employment, he has a right to bring an action to enforce such rights, which, if proven, would entitle him to adequate claim for damages. With due regards to the balance of convenience, a look at the entire paragraphs of the affidavit in support of the application filed by the first of the 7 defendants reveals that the first of the 7 defendants respondent will be prejudiced in the grant of the relief sought by the claimant's motion. From the affidavit of the first of the 7 defendants in support of their motion and notice, it is obvious that the claimant is due for retirement and the restraining order from retiring the claimant will be detrimental to the 7 defendants, as this would overreach the defendant since the claimant is already due for retirement. The implications of the grant of the claimant's application will be forcing the 7 defendants to retain the claimant as its employee with payment of salary contrary to the terms and conditions of their contract. This is per Olukayode Ariwala JSC in Abosede Hyde Laboratories PLC against the Union Merchant Bank Limited and another 2013 citation supplied, where the Supreme Court held, and I quote, "It has been held that the object of interlocutory injunction is to protect the plaintiff against injury by violation of his right, for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. Yet the plaintiff's need for such protection must be weighed against the corresponding need of the defendant to be protected against injury resulting from his having been prevented from exercising his own rights, for which he could not be adequately compensated under the plaintiff's undertaking in damages if the uncertainty were resolved in favor of the defendants at the trial." End of quote. It is imperative on the court, on this court, to weigh one need against the other in determining where the balance of evidence tilts. Based on the foregoing evidence, or based on the foregoing analysis, considering the rights of the parties to justice, it is the duty of this court to weigh the balance of convenience to determine where the balance of convenience actually tilts. With regards to whether damages can be adequate compensation, counsel to the claimant applicant argued that damages are not quantifiable due to the fact that the claimant applicant will be made to go bankrupt and reputation damaged. Counsel to the defendant's respondent was of the contrary view, maintaining that damages will be adequate compensation. I have considered the paragraphs of the affidavit in support of the claimant's application. In view of the said deposition in the affidavit, it is the view of this court that the award of damages can be adequate compensation based on the fact that the claimant is due for retirement and any perceived irregularities or breach in fair hearing by the defendants, if proven by the claimants at the trial, can be remedied by award of damages. Consequent upon the above authorities, I find that the application of the counsel of the claimant's applicant to be unmeritorious, and therefore same is hereby refused. Based on the foregoing reliefs, 1A and B and 2 of the defendants is put to rest and granted, as the claimant during the pendency of his employment with the 7 defendants is still subject to the terms and conditions of his employment, which is the Human Resource Policy Manual and Procedure, the staff handbook, which is signed with the 7 defendants and is to be retired and disciplined in accordance with the said terms. The second issue raised by the first to the 7 defendants is the joinder of the first to the 6th defendants as co-defendants in this action. Counsel contends that is a misjoinder in view of the fact that there is a disclosed principal, which is 7 defendants. The first to the 7 defendants, counsel contends further that the first to 6 defendants are not necessary parties to the suit and their names ought to be struck out. And in view of the fact that this matter can be effectively determined without joining them as parties to the suit. While it is the position of the claimant's counsel that the first to the 6 defendants are the alter ego of the 7 defendants, and that as agents of the 7 defendants, the first to 6 defendants are also necessary parties in this matter, this suit cannot be effectually determined without joining the first to the 6 defendants. In view of the contention above, it is imperative to determine the relationship of the agent and principal, per Gabriel Omani Akola Wale JSC in Fidelity Bank PLC against James Olariwaja and another 2019 citation supplied, where it was stated that an agent has been described as one who is authorized to act for or in place of another, end of quote. In Federal Capital Development Authority against John Ezinko in Navo, 2007 citation supplied, the court stated that, and I quote, "A person may decide to act by another as his agent and can benefit or bear the liability of that arrangement. One who authorizes is the principal, while the one authorizes the agent. The agent acts as if the principal who does the act." Based on the fact that the issue in the instant case is based on commercial law, I agree with the defendant that the rule of agents is not liable for his action, where there is a disclosed principal applies well in commercial law, more particularly in law of contracts, but cannot be same in torts. In a nutshell, North Local Government Council and orders against Mr. John Eze, 2016 citation supplied, the Court of Appeal held that, and I quote, "While I agree with the lower court and counsel on both sides on the bare bones of the statement of law that an agent of a disclosed principal is in some circumstances not liable for actions performed within the scope of authority, and only the principal is liable, I am afraid that they all misapply the principle to the instant action for thought. And that principle, very elementary law, that it only applies the way the lower court and the council reason in the area of commercial law, more specifically contract law. Hence, both parties are in agreement with the first to the six defendants as staff of the seven defendants, and acting on behalf of the seven defendant who is a party in the suit. Moreover, the seven defendant is a juristic person capable of suing and being sued. It should be noted that an act of an agent normally binds the principal rather than the agent himself, unless it is established that the agent acted outside the scope of the principal's instruction and was on its own frolic. In Judicial Lufthansa AG against Tochi Onyekachi Umogo 2021 citation supplied, the Court of Appeal held that, and I quote, in Leventis Technical Limited against Petro Jessica Enterprises Limited 1999, where the Supreme Court held that the act of an agent for a particular purpose is the act of the principal. The situation is in law as if it was the principal that did what the agent did or omitted to do. The common law rule expressed in the maxim qui per sepem face vital, which means he who does the act through another is deemed in law to do it himself. Considering the averment of the claimant, it can rightly be said that the first to the six defendants, being staff of the seven defendants, are acting on behalf of the seven defendants. Consequently, are they really necessary parties to be joined to the suit? In Oku and another against Ume and others, 2015 citation supplied, the court held that a necessary party is that person whose presence is essential for the effectual and complete determination of the issues before the court. It is a party in the absence of whom the whole claim cannot be effectually and completely determined. Please, end of quote, this per Okoro JSC. In Honorable Engineer Kobe Akila Duana, the court held that in order to determine whether or not Guyuk local government is a necessary party, the first place to look is the initiating process before the court, before the lower court, which set out both the claim and the reliefs which the plaintiff seeks. Hence, in the instant suit, the pleading in the statement of claim and the statement of and the reliefs of the claimant will be the determining factor to consider if the first to six defendants are necessary parties in the suit. I've considered the statement of claim of the claimant, particularly paragraph 3, which alleges that the first six defendants are staff of the seven defendants and head of various departments of the seven defendants. I've also considered the counter affidavit of the claimant in opposition to the first to seven defendants motion and notice, where the claimant alleges that the first to six defendants are the alter ego of the seven defendants and heads of department of the seven defendants. It should be noted that the seven defendants is a juristic person and should be accorded its corporate status of a separate entity, except in exceptional circumstances where the veil is lifted. In considering the fact that the first to six defendants are defendants, in considering the fact that the first to six defendants are staff of the seven defendants and we're acting on behalf of the seven defendants, who is a party in this suit, I find that it is possible to adjudicate the cause of matter without the first to six defendants as parties. The first to six defendants are parties whose presence before the court is not really necessary to enable the court to effectually and completely adjudicate and settle all the questions involved in this matter. Also, by virtue of the power vested upon this court by the provisions of Order 13, Rule 14, Sub 2 of the National Industrial Court Rules, which provides that a judge may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the judge to be just, order the names of any party or parties improperly joined to be struck out. In this regard, the names of the first to six defendants are hereby struck out from this suit for misjoinder. It should be noted that striking out the name of a party or parties for misjoinder does not in any way vitiate the claims of the claimants. Per Ebiowe Toby JSC in Emily Okafor against Yahya Jato, 2022 citation supplied, the Court of Appeal held, and I quote, the law on non-joinder or misjoinder is that they cannot defeat a claim. Please see Union Bank against Ugbe and others, 2019 citation. If it is a misjoinder, the name of the misjoined party will be struck out, while the judgment can be enforced against the proper party on record. For non-joiner, the court allows such a party to apply to be joined in an action, or even the respondents could have applied to join in the suit, and indeed even appeal as an interested party. More so, Order 13, Rule 14, Sub 1 of National Industrial Court Rules provides that no proceedings shall be defeated by reason of misjoinder or non-joinder of parties, and the judge may deal with the matter in controversy as it relates to the rights and the interests of the parties actually before the court. In the circumstances, however, this motion on notice of the defendant is considered meritorious, and same is accordingly granted. Ruling is accordingly entered, and make no order as to cost.
As the court pleases.
As the court pleases.
As the court pleases.
All right, have a nice day, gentlemen. This session comes to an end.
Thank you, my
We are
lord.
not grateful, my lord.
We are very grateful, my lord, for the well-considered ruling. Thank you.
We are more grateful, my lord.
I let her join though. Oh, I made a mistake. I didn't copy the number.